Hi, I'm Russ Weninger. I'm a wills and estate planning lawyer in Calgary, Alberta, Canada. Today I'm going to discuss ways in which you can describe or compartmentalize your estate, and I'll also talk about ways in which you can limit the scope of your will. In a will, the rest and residue, or simply the residue, refers to everything in your estate that wasn't otherwise mentioned in your will and given away as specific gifts. For example, a person might leave the rest and residue of their estate in 4 equal shares to their 4 children after leaving their stamp collection to their friend Montgomery Scott. A person can potentially divide the residue using percentages, but if you are doing so, you should double check and triple check the math. If the percentages don't add up, it can be a tremendous headache for your executor and beneficiaries down the road. Also, with percentages, you sometimes have to use awkward decimals. For example, if you're dividing your residue by 12. This may not be a problem when actually dividing your estate, but it may be a problem when drafting your will. For this reason, shares may be simpler than percentages. You can simply divide your estate into 12 equal shares, and you don't have to pull out the calculator. If you are leaving your estate to minor children or disabled adults, you may be using trusts. The executor is often designated as the trustee. As mentioned earlier, you can leave unspecified residual shares of your estate to beneficiaries, but you can also leave people specified gifts. Jewelry, artwork, a family home and its contents are all common specific gifts. The key thing to remember about specific gifts is that you can only leave what you own and what's available for distribution. For example, let's say you had a family farm, but the farm was incorporated. In other words, the farmland was owned by a corporation that you created. In that sort of scenario, you wouldn't be able to leave the farmland to someone in your will. The only thing that you would legally be able to do is leave someone some or all of the shares of the corporation that owned the farm. This may seem like a nitpicky distinction, but it's not. Sometimes gifts to beneficiaries are thwarted because the gifts aren't described properly. In another scenario, imagine that you are leaving your home to your spouse, but also leaving $100,000 to your adult daughter from a prior relationship. If you still own the home at your death, but only have $50,000 in savings, then your daughter will be left with something less than what she was expecting. If you have $100,000 at the time of your death, but no longer own the home, then your spouse may be left with nothing. This isn't a commonly used strategy in Alberta, but in other provinces such as BC and Ontario, people will often prepare 2 wills, with one will applied to probatable assets and the other will applied to non-probatable assets. This strategy is employed to minimize probate fees in jurisdictions where probate fees are based on the size of a person's estate. I won't go into details about what assets are probatable and what assets aren't. Suffice it to say that you should get advice on this specific issue from a lawyer if you have assets in jurisdictions such as British Columbia or Ontario. Different jurisdictions may have different probate requirements and different expectations regarding the drafting of wills. It may make sense to have a will apply only to assets held in one country or province, and then do one or more additional wills for assets held in other jurisdictions. Typically, a will contains a clause that revokes all prior wills. Such a clause can be extremely dangerous if you have deliberately written separate wills for separate asset classes or for assets held in different jurisdictions. Aside from being careful with revocation clauses, it's probably not a bad idea to reference the existence of other wills when you're stating that a will is meant to have limited applicability. Please check out my upcoming video in which I will discuss storage of wills and also talk about when a will should be updated. If you found this video to be helpful or informative, please feel free to like it or share it or subscribe to my channel. If you have a question, please leave it in the comments section and I will do my best to respond. While I don't want to give specific legal advice in the comments section, I will try my best to answer general questions, provided it is understood that my responses to comments should not be taken as legal advice, that social media interactions are not considered lawyer-client interactions, and that your safest course of action is to consult directly with me or another lawyer if you have a legal issue or would like to prepare a will. Thank you.